in Indira Nehru Gandhi versus Raj Narayan in 1975, Clause 4 of Article 329A, inserted by the Constitutional 39th Amendment Act 1975, was challenged on the ground that it destroyed the basic structure of the Constitution. The said Clause 4 provided that notwithstanding any court order declaring the election of the Prime Minister or the Speaker of Parliament to be void, it would continue to be void in all respect, and any such order and any finding on which such order was based would be deemed always to have been void and of no effect. This clause empowered Parliament to establish by law some authority or body for deciding the disputes relating to the election of the Prime Minister or Speaker. It provides that the decision of such authority or body could not be challenged before the court. This clause was declared unconstitutional and void as being violative of free and fair election, democracy, and rule of law, which are parts of the basic structure of the Constitution. In this case, judicial review, democracy, free and fair election, and rule of law were included in the list of basic features of the Constitution. Consequently, any constitutional amendment which takes away any of them will be unconstitutional and therefore void. And now we'll go to another most important leading case, that is Minerva Mills versus Union of India in 1980, as it was questioned Clause 4 and Clause 5 of Article 368, which is the amending article of the Constitution. So, it had been declared such amendment and insert of Clause 4 and 5 as to be invalid as they destroy the basic structure of the Constitution. These clauses have been inserted in Article 368 by the 42nd Constitutional Amendment Act 1976, and according to the very provision of Clause 4, no amendment of the Constitution, including the provisions of Part 3, which provide fundamental rights made to have been made under Article 368, shall be called in question in any court on any ground. And according to Clause 5, there shall be no limitation whatever on the constituent power of Parliament to amend by way of addition, variation, or repeal the provisions of the Constitution under Article 368. So the aforesaid Clause 4 was declared by the Supreme Court as unconstitutional on the ground that it took away judicial review, which is part of the basic structure of the Constitution. The aforesaid Clause 5 was declared unconstitutional on the ground that the limited amending power is one of the basic features of Indian Constitution, and this clause destroyed the feature by conferring unlimited power of amendment on the Parliament. And the last important leading case, and that relating to the finality clause or ouster clause or exclusion of judicial review is Satyabir Singh versus Union of India in 1980. The very Article 311 clause 3 was questioned. So, in that case, the court has held that in spite of Article 311 Clause 3, which provides that the decision of the authority empowered to dismiss or remove the government servant unquestioned whether it is reasonably practicable to hold inquiry against the servant before the disciplinary action is taken against him is final. Court can consider whether the power has been properly exercised, so it also falls under judicial review. And in another context, we'll discuss regarding para 6 of 10th schedule, provided that if any question aims as to whether a member of a house has become subject to disqualification under schedule 10th, the question shall be referred for the discussion of the chairman, or as the case may be, the speaker of such house, and his decision shall be final, provided that when the question which has been arisen is as to whether the chairman or the speaker of the house has become subject to such disqualification, the question shall be referred for the decision of such member of the house, as the house may elect in this behalf, and his decision shall be final. The court in this decision, and that is the very important decision of the court in the leading case, Prakash Singh Badal versus Union of India, and it was decided in 1987 by the Punjab and Haryana High Court. So the court has held that this para does not exclude the judicial review provided under Article 32, 136, 226, and 227. In spite of this para, the court can exercise its jurisdiction under the aforesaid articles. So the Supreme Court has held also that para 7 of the 10th schedule brings out changes in the effect of Article 136, 226, and 227, and therefore the Constitution 52nd Amendment Act, which has introduced the 10th schedule, is required to be ratified in accordance with the provisions to Article 368 Clause 2, but it was not ratified, and therefore para 7 is unconstitutional and void. So these are all relating to the constitutional provisions or the basic structure or the basic framework of the Constitution in relation to finality clause or ouster clause, and now we will discuss regarding the non-constitutional mode of judicial review is conferred on the civil courts by statute, and therefore it may be barred or excluded by the statute. So, Section 9 of the Civil Procedure Code 1908 confers a general jurisdiction to civil courts to entertain suits except where its jurisdiction is expressly or impliedly excluded. According to this section, the court shall have jurisdiction to try all suits of civil nature, except wherein its jurisdiction is expressly excluded. The jurisdiction of the civil courts and the statute is a self-contained code. Ouster clause or finality clause bars the jurisdiction of the civil courts. Thus, the express exclusion bars the jurisdiction of the civil courts. Implied exclusion of jurisdiction of civil courts is usually given effect where the statute containing the exclusion clause is a self-contained code and provides remedy for the aggrieved person or for the settlement of the dispute, as it was decided in the leading case Premier Automobiles Limited versus Case Wadke in 1975 by the Supreme Court. So, almost we have covered the constitutional mode of judicial review and the non-constitutional mode of judicial review, and in relation to constitutional mode of judicial review, almost we have discussed all the important leading cases such as Durga Shankar versus State of Bihar, Keshavananda Bharati versus State of Kerala, then Union of India versus J.P. Mittal, and the most important leading case Indira Nehru Gandhi versus Raj Narayan, Minerva Mills versus Union of India, Satyavir Singh versus Union of India, Prakash Singh Badal versus Union of India, and so also lastly the Premier Automobiles Limited versus Case Wadke in 1975, as it was also decided by the Supreme Court in relation to non-constitutional mode of judicial review as relating to Section 9 of the Civil Procedure Code 1908. So, in our upcoming video, we would like to discuss under what conditions or circumstances or situations the very exclusion clause could not be applied.